Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
3-bedroom colonial with a big backyard. Perfect for the kids. The price was right, the inspection came back clean, and the sellers were a sweet elderly couple. To save a little money, about $1,500, she decided to skip hiring a lawyer. Her real estate agent said it was a straightforward deal, and she found a standard purchase contract online. She signed on the dotted line, feeling savvy and in control. 3 months after moving in, she got a certified letter. It was from the city. It turns out the beautiful sunroom addition, the very room that sold her on the house, was built without a single permit. It was an illegal structure. The letter gave her 2 options: tear it down at her own expense, a cost of over $20,000, or go through a nightmarish year-long process to try and get it retroactively approved, with no guarantees. The standard contract she downloaded? It had no specific protections for unpermitted work. The $1,500 savings had just morphed into a $20,000 catastrophe. This isn't just a horror story. It's a cautionary tale that plays out in different ways all across the country. In the age of Zillow, online forms, and do-it-yourself everything, more and more people view a real estate lawyer as an optional, expensive line item. They think their agent protects them. They think the title company has them covered. And in many simple transactions, things go just fine. But the problem is, you never know if your deal is simple until it's too late. That stack of papers you sign at closing isn't a formality. It is one of the most complex and significant legal contracts you will ever sign, locking you into hundreds of thousands, or even millions of dollars of liability. Treating it like you're checking a box on a website is one of the single biggest financial risks you can possibly take. So that's what we're here to fix today. This video is your shield. We are going to walk through the 5 specific, high-stakes situations where not having a real estate attorney in your corner is like navigating a minefield blindfolded. We're not here to scare you. We're here to arm you with knowledge. By the end of this video, you will know the exact red flags to look for. You'll understand when your agent's expertise ends and when a lawyer's protection begins. You will be able to identify the hidden risks that can turn your American dream into a financial nightmare. And you'll know precisely when to say, "I need to call my lawyer." Let's start with the first and possibly most common situation where people get burned: buying a property with a cloudy title. Imagine this. You find it. The one. A beautiful, charming older home in a quiet neighborhood. It has character, a big backyard for the dog, and a price that miraculously fits your budget. You're in love. Your real estate agent, who's fantastic, gets your offer accepted. The inspection report comes back with a few minor, fixable issues. Everything is lining up. The seller is eager to close quickly, and you're just as excited to get the keys and start your new life. During the process, someone mentions a title search and title insurance. It sounds like just another box to check. Another fee in the mountain of closing costs. You're told the title company will handle it. You get a thick packet of documents a few days before closing, but it looks like a foreign language. You flip through it, see a bunch of whereas and heretofores, and figure, hey, that's what the title insurance is for, right? If there's a problem, they'll pay for it. So you sign on the dotted line, pop the champagne, and move in. Life is good. For 5 years, you make this house your home. You paint the walls, you plant a garden, you build memories. Then you decide it's time for that dream addition. A new primary suite off the back of the house. You hire an architect, get the plans approved by the city, and the construction crew shows up to break ground. On the 3rd day of digging, a man you've never seen before walks over from 2 streets away. He's holding a rolled-up piece of paper. He's polite but firm. He unrolls the paper, a faded property survey from 1968, and points to a line that runs right through the middle of your new foundation. "I'm sorry," he says, "but you can't build there. My family has a recorded access easement through this part of your yard to get to our landlocked parcel behind your house. It's been on the books for over 50 years. Your stomach drops. Your heart feels like it's been replaced with a block of ice. An easement? What's an easement? You call the title company frantic. They're sympathetic, but they point you to page 12, section 4, subparagraph C of your policy, the exception for all recorded easements and rights of way. The insurance policy acknowledged it was there, but it was your job or your lawyer's job to understand what it meant. Suddenly, your dream edition is dead. The thousands you've spent on plans and permits? Gone. The construction crew? They're packing up. And you're left with the giant, muddy hole in your backyard, and the sickening realization that you don't fully own the land you thought was yours. This, my friends, is the nightmare of a clouded title, and it is the absolute #1 reason you need a real estate lawyer. A property's title isn't the physical document you get at closing. That's the deed. The title is a legal concept. It's your bundle of rights to the property, the right to possess it, control it, and sell it. A clean title means your ownership is free and clear. A cloudy title means there's a question mark hanging over it. There's some issue, some claim, some unresolved problem from the past that could jeopardize your ownership. Think of it like buying a valuable classic car. The seller gives you the keys and a pink slip. But what if years ago the car was used as collateral for a loan that was never paid back? Or what if a co-owner never signed off on the sale? Or what if the VIN number was recorded incorrectly on a past sale, and technically the car still belongs to someone in another state? You wouldn't know just by looking at it. You need to run the vehicle's history report. A title search is the history report for your house, and a real estate lawyer is the master mechanic who knows how to read it. They're not just looking for obvious problems. They are trained legal detectives, searching for ghosts in the property's past. What kind of ghosts? First, you have liens. A lien is a legal claim against the property for an unpaid debt. The most common are tax liens from unpaid property taxes. But there could also be a mechanic's lien, from a contractor who renovated the kitchen for a previous owner and never got paid. Or there could be a judgment lien against a former owner from a lawsuit they lost. These liens act like financial barnacles attached to the house. If they're not discovered and paid off before you close, guess what? They become your problem. The contractor can come after you for the money, or the government could even foreclose on your home for the previous owner's unpaid taxes. Second, you have those pesky easements like in our story. An easement gives someone else the legal right to use a portion of your property for a specific purpose. It could be a shared driveway. It could be the utility company's right to access a power line in your backyard. Or it could be a 50-year-old path to a landlocked parcel you never knew existed. An easement could prevent you from building a fence, installing a pool, or adding on to your house. A lawyer won't just see the easement listed on the report. They will pull the original document, map it out on your survey, and explain in plain English exactly what it means for you and your future plans. Third, you have encroachments. This is when a structure on your property, or a neighbor's property, crosses the property line. Maybe your neighbor's garage was built 2 feet onto your land 30 years ago. Or maybe the beautiful old oak tree you thought was yours is actually your neighbor's, and its roots are tearing up your foundation. These are boundary disputes waiting to happen, and they can turn into incredibly expensive, bitter legal battles. A lawyer compares the title report with a new property survey to spot these issues before they become your fight to fight. And finally, the scariest one, breaks in the chain of title. The chain of title is the sequence of historical transfers of ownership for a property. A clean chain is an unbroken line from the current owner to the previous owner to the one before that, and so on. But sometimes that chain is broken. A deed could have been forged a century ago. A seller might have been mentally incompetent when they signed the papers. A property might have been passed down through a will that was improperly executed. Or, and this happens more than you'd think, a seller gets divorced, and their ex-spouse, who still has a legal claim to the house, never signed off on the sale. Years later, that ex-spouse can show up on your doorstep with their lawyer, claiming they are a rightful owner of your home. These are the ticking time bombs that a standard title search might note, but won't explain. The title company's job is to identify risks, and if you buy insurance, to cover certain financial losses after the disaster has already happened. A real estate lawyer's job is to be your advocate, your protector, to proactively find and defuse these bombs before you ever sign the contract. They don't just read the report, they question it. They demand proof that liens have been paid. They challenge ambiguities. They ensure that the person selling you the house has the 100% undisputed legal right to do so. So, when do you absolutely need one for title issues? Here are the red flags. If you are buying an older property with a long and complicated history, if the property is part of an estate or is being sold by heirs, if it's a foreclosure or a bank-owned sale, as these often come with messy title histories. If the property has unusual boundaries, is on a shared driveway, or has any other odd characteristics. Honestly, the risk is almost always there. The few $1,000s you might spend on a lawyer for a thorough review is a tiny fraction of the cost of your home. But it buys you something priceless: certainty. It's the difference between hoping you own your home free and clear, and knowing you do. It's the peace of mind that comes from knowing no ghosts from the past will ever show up to claim a piece of your future. Now, a cloudy title is a huge risk, but it's often hidden. The next situation is one that's staring you right in the face, but is so exciting that most buyers walk right into the trap. And that trap is the smell of fresh paint, the gleam of untouched appliances, and the promise of a home that is 100%, unequivocally yours. I'm talking about buying new construction directly from a builder. It feels like the safest bet in the world, doesn't it? There are no previous owners, no hidden rot, no ghosts of DIY projects gone wrong. You're not buying a house, you're commissioning a masterpiece. You walk through the model home and it's perfect. The lighting is immaculate, the staging is flawless, and the smiling sales agent makes you feel like family. They hand you a glossy brochure and a thick stack of papers, the builder's contract, and tell you it's standard. And that single word, standard, is the most expensive lie in real estate. That contract was not written by a neutral third party. It wasn't designed to be fair. It was drafted by a team of high-priced lawyers whose only job is to protect one person: the builder. Every clause, every sentence, every single word is a shield for them and a potential spear for you. Signing that contract without having your own lawyer review. It is like walking into a sword fight armed with a postcard. Let's imagine a couple, we'll call them Mike and Sarah. They've saved for a decade. They found the perfect development in a great school district. They're standing in the model home, picturing their future kids running down the hallway. The sales agent says, "We have a special incentive, but you have to sign today to lock it in." The pressure is on. They flip through the 80-page contract. It's dense, full of legalese. But it's standard, right? Everyone else signs it. What could go wrong? So they sign. 6 months later, the nightmare begins. The first thing they notice is the materials. The contract specified premium oak hardwood flooring. But the floors being installed look different. They're thinner, the grain is off. When they complain, the site manager points to a tiny clause on page 47. The right to substitute clause. It gives the builder the sole discretion to replace specified materials with others of reasonably similar quality. Who defines reasonably similar? The builder. The beautiful granite countertops they fell in love with? Replaced with a cheaper quartz. The high-end, energy-efficient windows? Swapped for a lower-grade model. Their custom dream home is slowly being built with bargain bin alternatives, and the contract they signed gives them zero power to stop it. Then come the delays. The original closing date was June 1st. Mike and Sarah sold their previous home and their lease on their rental is up June 15th. It's tight but manageable. In May they get an email. Due to supply chain issues, the new closing date is August 1st. Frantic, they scramble to find a short-term rental, putting most of their belongings in expensive storage. August 1st comes and goes. Another email. Now it's October. Now it's December. They're bleeding money on rent and storage. Their mortgage rate lock has expired, and interest rates have shot up, costing them hundreds of extra dollars every month for the next 30 years. They threaten to walk away, but the builder's agent calmly reminds them of the forfeiture clause in their standard contract. If they back out, the builder keeps their entire $50,000 deposit. They are trapped. The contract they signed has no penalties for the builder for these delays. It gives the builder the right to extend the closing date almost indefinitely for a laundry list of reasons, from weather to labor shortages to simply unforeseen circumstances. Finally, after a year of financial and emotional torture, they close on the house. Within 2 months, the paint starts peeling. A massive crack appears in the foundation. The master bathroom shower leaks into the kitchen below. They call the builder to file a claim under their 1-year bumper-to-bumper warranty. And this is where they learn the final brutal lesson. The builder's warranty isn't a promise. It's an obstacle course. The peeling paint? That's normal settling. The foundation crack? It's cosmetic and falls within acceptable tolerances. The leak? The warranty doesn't cover consequential damages to the kitchen ceiling. And the shower itself was installed by a subcontractor, so they need to chase them down. Every claim is a fight. Every fight is a dead end. The warranty, which seems so reassuring, is a fortress of exclusions designed to protect the builder from ever having to spend another dime on their home. Mike and Sarah are living in a brand new house that is already falling apart, with a contract that offers them no escape and a warranty that offers them no help. Now let's rewind. Let's put a real estate lawyer in the room on day one. Mike and Sarah, buzzing with excitement, take that 80-page standard contract not to their new pen, but to their attorney. The lawyer reads it, and the red ink comes out. First, that right to substitute clause. The lawyer strikes it. They add an addendum, a new legally binding part of the contract, that says any material changes must be approved by the buyers in writing, and if a specified material is unavailable, the replacement must be of equal or greater value, with the price difference credited to the buyer. No more cheap swaps. Next, the delays. The lawyer adds a time is of the essence clause. This makes the closing date a hard deadline. They negotiate a per diem penalty, a specific amount of money, say $200 a day, that the builder must pay the buyer for every single day the project is late past a reasonable grace period. Suddenly, the builder has a powerful financial incentive to finish the house on time. Then the deposit. The lawyer negotiates to have the deposit held in an escrow account, controlled by a neutral third party, and they modify the forfeiture clause. If the builder defaults or delays the project beyond a certain date, Mike and Sarah can walk away and get their entire deposit back. No questions asked. The trap is disarmed. Finally, the warranty. The lawyer scrutinizes the builder's warranty and finds it lacking. They might negotiate for a third-party home warranty, paid for by the builder, which offers much broader and more reliable coverage. They will also clarify the dispute resolution process, making sure Mike and Sarah don't waive their right to sue the builder in a real court of law, instead of being forced into binding arbitration, which is often a kangaroo court heavily favoring the corporation. For a fee that is a tiny fraction of the home's price, the lawyer has just transformed a one-sided contract from a weapon against the buyer into a shield that protects them. They've ensured the home will be built with the right materials on time, and with a real warranty to back it up. They've saved Mike and Sarah from a year-long $50,000 nightmare. So if you even think about buying new construction, your first call should not be to the sales office. It should be to a real estate lawyer. Because the most important thing you build isn't the house itself, but the legal foundation that ensures you get the dream you were promised. Protecting yourself from a corporation is one thing, but the financial and legal webs we weave can get even more tangled when the person on the other side of the table is someone you love. The next situation can turn a dream of building a life together into a battle that destroys both your finances and your relationship. Buying property with someone you're not married to. It sounds so modern, so smart, a wonderful way to build a future together. Whether it's your long-term partner, your best friend since kindergarten, or your sibling, pooling your resources to get onto the property ladder feels like a brilliant move. And in the warm glow of that shared dream, legal details feel cold, cynical, even insulting. You trust each other, right? You'll figure it out. You'll just put both your names on the deed 50-50. Simple. Except that one simple decision, made without legal counsel, is a ticking time bomb. It's the single most common reason that a dream home becomes a financial and emotional black hole for unmarried couples. Let's talk about a couple we'll call Mark and Jessica. They've been together for 6 years, deeply in love, and ready to buy their first condo. Jessica had been saving diligently and had a $60,000 down payment from her own savings and a gift from her parents. Mark had a higher income and a great credit score, so he would be covering the bulk of the monthly mortgage payments. They walked into the title company, and the closing agent asked them how they wanted to take the title. 50-50, they said, smiling at each other. Joint tenants. It sounded fair. Sounded like what partners do. They were a team. What they didn't understand is that in the eyes of the law, that 50-50 title was a blunt instrument. It completely ignored the reality of their financial arrangement. The law didn't see Jessica's $60,000 head start. It didn't see Mark's larger monthly contributions. It just saw two names equal partners. For 3 years, everything was perfect. They painted the walls, hosted parties, and built a life. But relationships can be fragile. They broke up. It was heartbreaking, but they wanted to be amicable. Then they had to decide what to do with the condo. The property had appreciated by $40,000. Jessica said, "Okay, when we sell, I should get my $60,000 down payment back first. Then we can split the $40,000 profit." That sounds reasonable, doesn't it? But Mark, now feeling hurt and defensive, said, "Hang on. The title says we're 50-50 owners. I paid way more into the mortgage for 3 years. I should get half of everything. Even worse, he couldn't afford to buy her out, and he refused to sell, wanting to stay in the home they'd built. Suddenly, they weren't amicable exes. They were adversaries in a legal cage match. And the law by default was on Mark's side regarding the 50-50 split of the equity. Jessica was facing the horrifying reality that half of her life savings could simply vanish. Their simple romantic decision had become a legal nightmare that would cost them thousands in legal fees, force a court-ordered sale of the property, and utterly destroy any chance of a peaceful separation. This is the trap. When a married couple buys a house, there is a vast, established body of law, divorce law, family law, that governs how assets are divided. Courts look at who contributed what, the length of the marriage, and aim for an equitable distribution. But for unmarried owners, the law often defaults to the simplest, coldest interpretation of the title deed. Tenancy in common? You each own your percentage. Joint tenancy? You own it together equally. The nuances, the verbal agreements, the fairness of it all? It often means nothing without a written agreement. A real estate lawyer's job in this situation is to be the adult in the room before you sign on the dotted line. They aren't there to cast doubt on your relationship. They're there to protect it. They do this by helping you create a co-ownership agreement, sometimes called a property agreement or a tenancy agreement. Think of it as a prenup for your house. It's a document that you create when everyone is happy and in love, that dictates exactly how things will be handled if you're not. First, the lawyer will explain your ownership options. The two most common are tenants in common and joint tenants with right of survivorship. Joint tenancy is what Mark and Jessica chose. It includes the right of survivorship, which means if one partner dies, the other automatically inherits the entire property. This is often what couples want, but tenants in common allows you to own unequal shares. You could structure it so Jessica owns 60% and Mark owns 40%, or any other split that reflects your contributions. Crucially, with tenants in common, if you die, your share doesn't automatically go to your co-owner. It goes to whoever you designate in your will. This is vital if you have children from a previous relationship that you want to inherit your stake in the property. A lawyer helps you choose the structure that actually matches your life and your intentions. But the most critical part of the co-ownership agreement is the exit strategy. Your lawyer will sit down with you and force you to have the awkward, essential conversation. They'll ask the what-if questions that feel pessimistic but are profoundly practical. What if one of you wants to sell and the other doesn't? The agreement can build in a buyout clause. It will specify the process. You'll get 2 or 3 independent appraisals, average the value, and the partner who wants to stay has a set amount of time, say 90 days, to secure financing to buy the other partner out. No arguments about the price, no stalling. It's a clear, pre-agreed upon mechanism. What if the remaining partner can't afford the buyout? The agreement will state that if a buyout isn't completed in the specified time, the property must be listed for sale with a licensed realtor at the appraised market value. This prevents one person from holding the other's equity hostage out of spite or indecision. And most importantly, the agreement will detail the financial split. It will explicitly state that upon sale, Jessica's $60,000 down payment is returned to her off the top, before any other profits are calculated. It can even account for unequal mortgage payments, specifying a formula for how the remaining equity is to be divided to reflect those contributions. All of those messy, emotional arguments that Mark and Jessica had, they would have been replaced by a single, boring page in a legal document they both signed years earlier. The breakup would still be painful, but the financial separation would be a clean, simple business transaction. They might have even walked away as friends. And it gets even darker if you don't have this in place. What if one partner dies unexpectedly? With joint tenancy, the other inherits. But what if you chose tenants in common to protect your kids but you never wrote a will? The laws of intestacy kick in. Your share of the house could pass to your parents or your siblings. Your surviving partner, grieving and vulnerable, could suddenly find themselves co-owning their home with their in-laws, who might want their money out immediately and force a sale. A lawyer ensures your property plan is integrated with your estate plan, preventing a tragedy from becoming a catastrophe. The cost for a lawyer to draft a co-ownership agreement is minuscule, a tiny fraction of a single mortgage payment. But its value is immeasurable. It protects your investment, your savings, and most of all, it protects your relationship from the predictable poison of ambiguity. It allows you to enter into one of the biggest financial decisions of your life with clarity and security, ensuring that the home you build together is a source of joy, not a future battleground. The painful truth is that while love may feel infinite, a real estate transaction is all about finite details. And ignoring those details is a mistake you can't afford to make. But what happens when the problem isn't with the person you're buying with, but with the property itself? Sometimes the most dangerous threats are the ones you can't see. The ones buried in old surveys, hidden in city zoning codes, or lurking just beyond your property line. The next situation we're going to cover is when the lines on the map don't match the reality on the ground, and your dream home is secretly sitting on a legal landmine. This is situation number 3, and it's one of the most common and emotionally draining legal battles a homeowner can face: boundary disputes, easements, and encroachments. Imagine you finally did it. You bought the house with the perfect backyard. It's got a beautiful weathered wooden fence, a majestic old oak tree right on the edge of the property that's perfect for a tire swing, and a handy little shed tucked away in the back corner. You close the deal, you move in, you spend the first month painting, unpacking, and planning your first big backyard barbecue. Then one sunny Saturday morning, your new neighbor, a seemingly pleasant guy named David, wanders over while you're mowing the lawn. After some friendly small talk about the weather, he gets this slightly awkward look on his face and says, "Hey, not to be a bother, but I just had a new survey done for a patio I'm putting in. And well, it looks like this fence is about 4 feet onto my property." You laugh it off. A mistake surely. But David isn't laughing. He pulls out a crisp, new survey map with bright pink flags marking the corners. And your blood runs cold as you see it. The line on his map slices straight through what you thought was your yard. That beautiful fence? It's on his land. The majestic oak tree? The trunk is technically more on his side than yours. And that incredibly useful shed in the corner? According to this map, it's not in the corner of your yard. It's sitting squarely in the middle of his. Suddenly, your American dream comes with a 4-foot-wide nightmare attached. David, who seemed so nice a minute ago, is now talking about tearing down his fence and asking when you plan on moving your shed off his property. What do? Your real estate agent is long gone. This isn't their problem. Your title insurance policy might cover some of this, but it's a dense, complicated document, and you're not even sure what to look for. You're in a full-blown legal dispute, and you didn't even see it coming. This is the moment you don't just need a lawyer. You need a specialist. A real estate attorney is the only person equipped to navigate this minefield. Your first instinct might be to argue, to pull out your own closing documents and point at the pictures. But in the world of property law, feelings don't matter. Old handshakes don't matter. What matters are surveys, deeds, and centuries of established legal principles with names like adverse possession and prescriptive easement. When you hire a real estate attorney, the first thing they'll do is stop you from talking to David. They become the buffer, the calm, strategic mind in an emotional storm. They will tell you not to move the shed, not to touch the fence, and not to agree to anything. Next, they launch their own investigation. They won't just accept David's new survey. They'll hire their own licensed surveyor to do a completely new, independent analysis of the property. Surveying isn't always an exact science. Surveyors can make mistakes, reference the wrong starting points, or misinterpret old records. Your lawyer will get a second and sometimes even a third opinion. While the surveyors are at work, your lawyer is digging through the history of your property. They'll pull every deed and every survey on record for both your house and your neighbors going back 50, maybe even 100 years. They're looking for discrepancies, for clues. Maybe the original subdivision map from 1950 had a clerical error that's been copied from deed to deed ever since. Maybe an old iron pin marking the true corner is buried under 2 feet of dirt and was missed by the new survey. This is where the legal magic happens. Let's say the survey confirms the fence and shed are, in fact, on David's side of the line. Is it case closed? Do you have to tear everything down? Not necessarily. Your lawyer will explore the doctrine of adverse possession. In many states, if you and the previous owners of your home have used a piece of land openly, continuously, and without the owner's permission for a certain number of years, it could be anywhere from 5 to 20 years depending on the state, you can actually claim legal ownership of that land. That fence that's been there for 30 years? It might have legally redrawn your property line without anyone realizing it. Proving this is incredibly complex and requires a deep understanding of state-specific law, but it can be a powerful tool. Then there's the concept of a prescriptive easement. This is similar to adverse possession, but instead of claiming ownership, you claim the right to use the land. Maybe you can't prove you own the land the shed is on, but your lawyer might be able to argue that because the shed has been there for so long, You've earned an unbreakable legal right, an easement to keep it there forever. What about that oak tree? Your lawyer might find local ordinances or state laws about boundary trees, which are often considered the common property of both homeowners, giving you rights to the tree even if the trunk isn't entirely on your land. Armed with this research, your lawyer's primary goal isn't to drag you into a costly court battle. Their goal is to find leverage and negotiate a solution. They'll present their findings to David's attorney. Suddenly, David's slam dunk case isn't so simple anymore. The prospect of a long, expensive fight in court over adverse possession claims now looms over him. This is when real solutions happen. Your lawyer might negotiate a lot line adjustment, where you legally purchase that 4-foot strip of land from David for a fair price, making it officially part of your property forever. Or they might draft a formal easement agreement, where David legally grants you the right to keep the shed and fence where they are. An agreement that gets recorded with the deed and protects all future owners of your home. In the best-case scenario, the lawyer saves your yard, your shed, and your sanity. In the worst-case scenario, where your neighbor is completely unreasonable and a lawsuit is unavoidable, your lawyer is the one who will file what's called a quiet title action, asking a judge to step in and make a final binding decision on who owns what. Going to court is the last resort, but sometimes it's the only way to protect your biggest investment. So, when do you need the lawyer? You need them the second a boundary issue comes up. Don't wait. Don't have a friendly chat that turns into a shouting match. Don't offer to split the cost of moving the fence, because doing so could be seen as you admitting the fence is in the wrong place, weakening any future legal claim you might have. The moment a neighbor questions a property line, your first call should be to a real estate attorney. The few $100s for that initial consultation can save you from a $10,000 mistake, a $50,000 lawsuit, and the immeasurable stress of being at war with the person you share a hedge with. We've covered the seller hiding defects in the house, and we've covered the land itself hiding secrets within its boundaries. But what happens when the problem isn't with the physical property at all? What happens when the issue is with the people on the other side of the table? When you're buying a home from a couple in the middle of a nasty divorce, inheriting a property with 5 other feuding family members, or dealing with a seller who suddenly dies days before closing. That's when the paperwork can become a war zone. And without a lawyer, you could find yourself caught right in the crossfire. And that brings us to our first major red flag. The first situation where going in without a lawyer is like trying to defuse a bomb with a butter knife. And that is when you are buying or selling a property with even the slightest hint of a title issue. Now, the word title gets thrown around a lot. Most people think it's just the physical piece of paper, the deed, that says you own the house. But that's not it. That's like saying your driver's license is your ability to drive. The deed is just the proof. The title is the whole story. It's the property's entire legal history, its DNA. It's the unbroken chain of ownership stretching back decades, sometimes even centuries. And it's the legal undisputed right for you to own, use, and eventually sell that property. When that chain is clean and unbroken, it's called a clear title. But when there's a problem, a forgotten debt, a disputed boundary, a mistake made 50 years ago, it's called a cloud on the title. And that cloud can turn into a hurricane of legal and financial problems for you, the new owner. Let me tell you a story about a guy named David. David and his wife found their perfect forever home. A beautiful colonial with a huge backyard for their kids, in a great school district. The price was a little under market value, which they saw as a huge win. The sellers were an elderly couple looking to downsize quickly. Everything felt perfect. To save a few $1,000s, David decided against hiring his own attorney. He thought, I have a great realtor and I'm buying title insurance. What could possibly go wrong? They closed the deal, moved in, and for 6 months it was paradise. They painted the kids' rooms, planted a garden, and hosted a barbecue for the new neighbors. Then, one Tuesday afternoon, a certified letter arrived. It was from a lawyer representing a major solar panel company. The letter stated that the previous owners had signed a 20-year lease agreement for solar panels that were never actually installed. But the contract they signed had been recorded as a Use 1 financing statement against the property. In simple terms, it was a type of lien, a multi-$1,000 debt that was legally attached, not to the old couple, but to the house itself. The solar company now wanted David to either pay the full remaining balance of the contract, about $30,000, or they would begin foreclosure proceedings. David was in shock. His blood ran cold. Foreclosure? He'd been paying his mortgage on time every time. He called his realtor, who was sympathetic but could only say, "I'm sorry, David, that's a legal issue. You need to talk to a lawyer." Then he called the title insurance company. And this is the critical lesson that so many people learn the hard way. The title insurance agent pulled up his policy and pointed to a tiny exception on page 7. It said the policy did not cover issues that were not part of the standard county land records search. And because this UCC1 was filed with the state, not the county, it wasn't covered. He was on his own. David had walked straight into a legal landmine that a real estate attorney would have spotted from a mile away. You see, a lawyer's job isn't just to shuffle papers at closing. Their primary job is to protect you. Before you ever get to the closing table, your attorney would have conducted what's called due diligence. They would have initiated a comprehensive title search that goes far beyond the basic check. They would have searched county records, state records, civil court records, and bankruptcy filings. They would have found that solar panel lien. But here's the key difference. They don't just find the problem, they solve it. An attorney would have immediately halted the process and said, "Mr. Seller, you have a $30,000 cloud on this title. You are legally required to deliver a clear title. You need to pay this off before we proceed. If you don't, my client is walking away from this deal, and you'll have to disclose this lien to every future potential buyer." The problem would have been solved by the seller, at the seller's expense, before David ever signed a single document. That's the proactive protection you pay for. Title insurance, on the other hand, is almost entirely reactive. It's a policy of indemnity. That means it's designed to compensate you for a financial loss after the disaster has already happened. It doesn't prevent the nightmare. It just cuts you a check for it later, assuming your specific problem is even covered, and you might have to sue them to get it. David's story is just one example. These clouds come in all shapes and sizes. Let's talk about a few of the most common ones. First, you have liens like David's. The most common are tax liens from unpaid property taxes. But you can also have mechanics liens, where a contractor who worked on the house for the previous owner was never paid. They can slap a lien on the property, and guess who's responsible for it now? You. There can be liens from unpaid HOA dues, or even a judgment lien if a previous owner lost a lawsuit and had a judgment placed against their assets, including the house. Second, there are easements and encroachments. An easement is a legal right for someone else to use a portion of your property for a specific purpose. Maybe the utility company has an easement to access a power line in your backyard. That's usually fine. But what if there's an old, unrecorded easement that gives your neighbor the right to use your driveway to get to their garage? You think you're buying a private driveway, but you're actually buying a shared road. An attorney would uncover this and explain the real-world implications to you before you buy. Encroachments are even worse. This is when a physical structure illegally extends onto your property. Imagine finding out 6 months after you move in that your neighbor's new garage is actually 3 feet over your property line. Or the horror scenario. A survey reveals that the back corner of the house you just bought is actually sitting on your neighbor's land. This is a 5-alarm legal fire, and without a lawyer to have ordered and meticulously reviewed a new survey before closing, you are now the one holding the hose. Third, and this is the scariest one, are errors in the chain of title. This is the property's ancestry. What if a deed from 1965 had a forged signature? What if a property was passed down to 3 children, but only 2 of them signed the deed when it was sold? That third child, or their heirs, could potentially show up on your doorstep one day with a valid legal claim to a portion of your property. These are complex, deep-seated issues that only a trained legal eye, someone who understands the nuances of probate law and property conveyance, is going to catch. They'll see a name on a deed from 40 years ago and say, "Wait a minute, the death certificate for this person's spouse was never filed with the deed. We need to prove they had the right to sell this property alone." That's the level of detail that saves you from catastrophic risk. So when you're standing at the beginning of a real estate transaction, and you're thinking about skipping the lawyer to save a little money, picture David. Picture the certified letter, the pit in his stomach, and the $30,000 bill for a mistake that wasn't even his. The fee for a good real estate attorney is not a cost. It is an insurance policy against the unknown. It's the price of certainty. It's paying a professional to read every line of every dusty document to make sure that the home you're buying will be, without a shadow of a doubt, legally and completely yours. Now, being legally and completely yours is a straightforward concept when you're buying from, say, the Johnsons down the street. But what happens when the Johnsons aren't the sellers? What happens when you're buying a property from a situation, not a person? This brings us to our third absolute: Non-negotiable, must-have a lawyer scenario. Buying a property from an estate or as part of a divorce. These aren't just transactions. They are the financial fallout of life's most stressful events. And when emotions run high, legal oversight isn't a luxury. It's a survival tool. Let's start with an estate sale. Imagine you find the perfect house. It's a beautiful colonial great neighborhood. Exactly what you've been dreaming of. The owner, an elderly woman, passed away a few months ago, and her son David is the executor of her will and is handling the sale. Seems simple enough. David is motivated, the price is fair. You make an offer, it's accepted. You're thrilled. You start picking out paint colors, measuring for curtains. Then 2 weeks before closing you get a call. The sale is on hold. A sister, who hasn't spoken to the family in a decade, has emerged from the woodwork. She's contesting the will, claiming their mother was not of sound mind when she wrote it and that David, the executor, doesn't have the legal authority to sell the house. Suddenly, your dream home is the centerpiece of a bitter family feud. Your mortgage rate lock is about to expire. You've already given notice on your apartment. Your life is thrown into complete chaos. What do? This is where your agent, as great as they may be, has to step back. This is no longer a real estate negotiation. It's a probate court issue. But your real estate lawyer? They step forward. This is their arena. The first thing your lawyer does is demand to see the court-issued document called letters testamentary. This is the official decree that grants the executor, in this case David, the legal power to act on behalf of the estate. It's not enough for him to just say he's in charge. Your lawyer verifies it with the court. Next, they tackle the contesting sister. Your lawyer will communicate directly with her attorney, insulating you from the drama. They'll work to get a court order or a signed agreement from all potential heirs, including the sister, consenting to the sale. This ensures that after you close, no one can come back and claim a right to your property. They are essentially clearing the legal fog before you walk through the door. They will also amend your purchase contract with specific clauses protecting you. Clauses that make the sale contingent on court approval, or that guarantee the estate will pay for any legal challenges that arise, protecting your deposit and your future ownership. Without a lawyer, you could easily lose your deposit, get tangled in a lawsuit that has nothing to do with you, or worse, buy the house only to have the sale invalidated by a judge months later. Buying from an estate is buying from the past, and a lawyer is the only one qualified to make sure that past doesn't come back to haunt your future. Now, let's take that emotional complexity and multiply it by 10. Welcome to buying a house from a divorcing couple. Here, the sellers aren't a team working together to sell their home. They are often adversaries, and the house is a battleground. One spouse might agree to a repair, and the other will refuse out of pure spite. One might forget to sign a crucial document, intentionally delaying the process to inflict pain on the other. They may fight over who gets the proceeds, who pays for the last-minute roof leak, or even who gets to keep the fancy refrigerator. You, the buyer, are caught in the crossfire. A real estate lawyer becomes your shield and your strategist. They don't just draft a standard contract. They draft an ironclad agreement that anticipates the conflict. It will specifically detail every single obligation, from repairs to paperwork, and have both spouses sign it. It removes ambiguity, which is the fuel for these kinds of disputes. Your lawyer will also coordinate directly with the couple's divorce attorneys. They will review the divorce decree or separation agreement to ensure the sale of the home complies with the court's orders. Is one spouse supposed to receive a larger share of the proceeds? Is there a court-ordered lien called a lease pendens on the property that needs to be removed before closing? Your lawyer handles all of it. They ensure that all the legal requirements of the divorce are satisfied so that once you buy the house, the seller's marital problems are not your legal problems. In these situations, a lawyer isn't just reviewing documents. They are managing a crisis. They are protecting your investment from the emotional and legal shrapnel of someone else's life falling apart. Now let's move from emotional distress to financial distress. This is our fourth situation where a lawyer is absolutely critical. You're buying a distressed property. This includes foreclosures, short sales, or homes bought at auction. The allure is obvious. A potential bargain. The chance to get a property for far below market value. But the price of that potential discount is a massive increase in risk. These aren't normal sales. They are the complex unwinding of a financial failure. Let's start with a bank-owned foreclosure, also known as an REO or real estate-owned property. You're not buying from a person, You're buying from a massive, faceless financial institution. The bank's #1 priority is not your happiness. It's limiting their liability. Their purchase agreements are not standard one-page documents. They come with a 20 or 30-page addendum, written by their team of high-priced lawyers, designed for one purpose: to strip you of almost every protection a normal buyer has. The property will be sold as is, where is, which means they guarantee absolutely nothing. Not the plumbing, not the roof, not even that the title is clean. You might think, wait, the foreclosure process is supposed to wipe out other liens. Supposed to. But what if the bank's lawyers made a mistake in the foreclosure process? What if they failed to properly notify a second mortgage holder or the IRS? Those liens could survive the foreclosure and attach to you, the new owner. You could buy a house for $200,000, only to find out you've inherited a $50,000 IRS lien. A real estate lawyer reads the bank's addendum not as a buyer, but as an opposing attorney. They identify the traps. They can translate the dense legalese and tell you exactly what rights you're signing away. In some cases, they can even negotiate to have the most aggressive clauses removed. Most importantly, they will conduct a forensic-level title search, specifically looking for errors in the original foreclosure filing that could cloud your title. They are your defense against the bank's army of lawyers. Then you have short sales. This is where the homeowner owes more on their mortgage than the house is worth, and the bank agrees to let them sell it for less to avoid the cost of foreclosure. This sounds great, but it creates a maddeningly complex triangle of negotiations. You negotiate with the seller, who has no financial incentive, and the seller's bank, the real decision maker, has to approve every detail. The bank is losing money, so they are in no hurry. It can take months, sometimes over a year, to get a short sale approved. During that time, you're just waiting. The bank can come back and demand a higher price, change the terms, or just flat out deny the sale for an internal reason they'll never disclose to you. An experienced real estate attorney is a master navigator of this bureaucratic maze. They know how to package the offer and the seller's financial information in a way that the bank's loss mitigation department can process efficiently. They know who to call to escalate a file that's been sitting on someone's desk for 60 days. They will draft an offer that protects you, with deadlines and escape clauses that allow you to walk away with your deposit if the bank drags its feet for too long. They manage the process so you don't lose your mind or your money. Whether it's a foreclosure, a short sale, or an auction property, you are stepping into a legal and financial minefield. Going in without your own legal expert is like trying to defuse a bomb with a butter knife. The potential savings are just not worth the catastrophic risk. So we've covered the hidden dangers of title, the emotional chaos of estates and divorces, and the financial minefields of distressed sales. All are complex situations where the game is rigged against the average buyer. But what if the situation is the complete opposite? What if you're not buying a problem property, but a perfect brand new one straight from the builder? Surely you don't need a lawyer when you're the very first owner and everything is pristine? Or do you? That's where things get surprisingly complicated. This is our fourth situation. You're buying a brand new home directly from a builder. Feels like the safest transaction imaginable. No previous owners, no hidden rot, no shoddy DIY repairs from the 1970s. Everything is under warranty, and you have the builder's friendly sales agent guiding you every step of the way. It's a clean slate, and that clean slate is precisely what makes it one of the most dangerous transactions you can enter without a lawyer. Why? Because of the contract. When you buy a resale home, you typically use a standard state-approved Board of Realtors promulgated contract. These forms have been tweaked and litigated for decades. They are designed to be relatively balanced, protecting both the buyer and the seller. When you buy from a builder, you don't use that contract. You use the builder's contract, a document drafted by the builder's high-powered attorneys with one singular purpose: to protect the builder from everything and anything that could possibly go wrong, while shifting as much risk as possible onto you, the buyer. Signing a builder's contract without legal review is like agreeing to a sword fight, but you let your opponent write the rules, choose the weapons, and bring their own referee. The odds are not stacked in your favor. They're stacked on a different planet. Let's break down the traps hidden in plain sight. First, and most common, is the materials and substitution clause. You tour the model home. You fall in love with the gleaming Calacatta gold quartz countertops, the rich American walnut hardwood floors, and the high-end Kohler fixtures in the bathroom. The sales agent assures you this is the quality you can expect. You sign the lengthy contract, which you skimmed but didn't fully absorb. Halfway through construction, The builder's supplier for that specific quartz has a shortage. The contract you signed contains a little clause that says the builder has the right to substitute materials with something of substantially equal or better quality at their sole discretion. Suddenly, your dream quartz countertops are replaced with a lower grade, generic brand of engineered stone that you hate. The rich hardwood is swapped for a cheaper laminate that scratches if you look at it wrong. When you complain, the builder points to the contract. Their interpretation of substantially equal is very different from yours. And because you signed it, you have no legal ground to stand on. A real estate attorney would have seen that clause from a mile away. They would have redlined it and negotiated for an addendum that specifically lists the make, model, and color of your desired finishes. Or, at a minimum, they would have added a provision stating that any substitution requires your written consent and a corresponding price reduction if the new material is less expensive. That one change protects the very vision of the home you're paying for. Next up is the delay clause, the silent killer of budgets and sanity. The builder gives you a closing date, say 8 months from now. You plan your entire life around it. You sell your current home, you arrange for movers, you lock in your mortgage rate. But buried on page 37 of the contract is a paragraph that essentially gives the builder the right to delay the closing for, well, forever. They list everything from weather delays and material shortages to labor disputes, and any other causes beyond its control. The definition of beyond its control is often so broad it could include a cloudy Tuesday. So your closing date of June 1st gets pushed to August 15th, then to October, then to the following January. In the meantime, your mortgage rate lock has expired, and interest rates have jumped a full percentage point. Your monthly payment is now hundreds of dollars higher for the next 30 years. You're also bleeding money on a short-term rental and storage unit fees. You are completely at the builder's mercy. A lawyer fights this. They negotiate a time is of the essence clause, which makes the closing date a hard deadline. While most builders will refuse that, a good lawyer can negotiate a compromise, an outside closing date or a drop-dead date. This means that if the home is not completed by a specific final date, the builder starts paying you penalties for every day they are late. This could be $100 or $200 a day to cover your rental and storage costs. It puts real financial pressure on the builder to finish your home and protects you from indefinite, costly delays. Then there's the scariest trap of all, the merger clause and the warranty. The friendly sales agent is your best friend during the sales process. They make all sorts of verbal promises. Oh, you want an extra electrical outlet on that wall? No problem, we'll take care of it. Don't worry about the backyard, we always grade it and lay down sod before closing. Yes, that upgraded appliance package is included at this price. You believe them. You trust them. But then you sign the contract, which contains what's called a merger clause or an integration clause. This little piece of legal jargon says that this written contract is the final and entire agreement between you and the builder. It supersedes any and all prior discussions, negotiations, and oral promises. In an instant, every single verbal promise that sales agent made to you evaporates. If it wasn't written into the contract as an addendum, it legally never happened. To make matters worse, that same contract will often have the builder disclaiming all the powerful, state-mandated warranties of workmanship and habitability that normally protect new homebuyers. They replace them with their own, much more limited private warranty. This warranty might exclude the foundation, have dozens of loopholes, and require you to go through a complicated arbitration process instead of court if something goes wrong. Your attorney's job is to be the official record keeper. They will create a detailed addendum that lists every single promise made by the sales agent, every upgrade, every specific detail, and make it a legally binding part of the contract. They will also review the warranty provisions, fighting to preserve your statutory rights and explaining to you exactly what is and isn't covered, so there are no devastating surprises a year after you move in. Finally, builders often offer powerful incentives, maybe $10,000 or $20,000 in closing costs, if you use their preferred lender and title company. Seems like a no-brainer. But who do those preferred partners really work for? You, the one-time customer? Or the builder who sends them hundreds of deals a year? Their loyalty is to the builder. The lender might not be offering you the most competitive rate, and the title company might be more inclined to overlook minor issues that could delay the builder's payday. A lawyer can help you analyze whether that incentive is truly a good deal, or just a golden leash that ties you to a team that isn't really on your side. Buying new construction should be an exciting experience, but the builder has a team of lawyers protecting their interests. Going into that negotiation alone is a financial and legal mismatch of epic proportions. Hiring a lawyer isn't about being adversarial. It's about leveling the playing field. It's about turning the builder's self-serving manuscript into a fair, balanced contract that protects your massive investment and ensures the dream home you were promised is the dream home you actually get. So we've covered the hidden dangers of buying a brand new home. But what about the opposite end of the spectrum? What if the transaction seems incredibly simple, almost informal? What if there's no bank, no real estate agents, just a simple transfer of property between people who trust each other implicitly? I'm talking about buying from or selling to your own family. Surely you don't need a lawyer when you're dealing with your parents or your siblings, right? That assumption is the doorway to our fifth and final situation, where good intentions can pave a direct road to financial ruin and family feuds that last a lifetime. This is situation number 5. Any real estate transaction between family members. It's the single most emotionally and financially dangerous transaction you can ever undertake without a lawyer, precisely because love and trust are involved. Let's paint a picture. Meet the Andersons, a wonderful couple, Mark and Carol, in their late 60s. They've decided to downsize and want to sell their beloved family home to their youngest daughter, Emily, who just got married. They want to give her a head start, so they agree to sell it to her for $200,000, even though it's easily worth $400,000. Everyone is happy. Mark and Carol get to keep the house in the family, and Emily gets an incredible deal. Her older brother Tom, who lives across the country, seems fine with it too. He's financially stable and just wants his sister to be happy. So they go online, download a standard quitclaim deed form, fill it out at the kitchen table, get it notarized at their local bank, and file it with the county. They skip the real estate agents, the appraisers, the inspectors, and of course the lawyers. Why would they need them? This is family. It's a deal built on a lifetime of trust. They've just saved thousands of dollars in fees. Feels like a huge win. For about 5 years it is. Then, Mark and Carol pass away unexpectedly in a car accident. And the foundation of trust that their entire transaction was built on, it shatters into a million pieces. When the will is read, Tom discovers the estate is much smaller than he anticipated. His resentment over the house deal, which he buried for years, suddenly boils over. He hires a lawyer and sues Emily, claiming she exerted undue influence on their aging parents to get the house for a fraction of its value. He argues it wasn't a sale, it was an early inheritance that cheated him out of his rightful share. Suddenly, Emily is in a legal battle that costs tens of thousands of dollars. The kitchen table deal, the simple quitclaim deed with no supporting documents, is now Exhibit A against her. There's no formal sales contract outlining the terms. There's no appraisal to officially document the value of the home at the time of the sale. There's no paper trail showing Mark and Carol were of sound mind and acting freely. It's Emily's word against her brother's accusations. The family is torn apart, spending their inheritance on legal fees to fight each other in a bitter public feud. But the nightmare doesn't stop there. Let's say Emily wins the lawsuit. A year later, she and her husband decide to divorce. Her husband's lawyer argues that the $200,000 of gifted equity from her parents is a marital asset. Why? Because there was no legal document from her parents clearly stating that the equity was a gift intended solely for their daughter, separate from the marital estate. Now, she risks losing half of her parents' legacy to her soon-to-be ex-husband. And there's still one more landmine. A few years later, Emily wants to sell the house. The title company runs a search and discovers a fatal flaw. The quitclaim deed the Andersons downloaded from the internet? It's a document that offers zero protection or guarantees. It basically says, I'm giving you whatever interest I think I have in this property, but I'm not promising I actually own it free and clear. It turns out, there was a tiny unresolved lien from a contractor from 30 years ago that Mark and Carol had forgotten about. A warranty deed, which a lawyer would have insisted on, would have guaranteed the title was clear. But the quitclaim deed transferred the property along with all its hidden problems. Now Emily can't sell the house. The sale falls through, she loses the down payment on her new home, and she has to spend thousands more to hire a lawyer to go to court and file a quiet title action to clear the old lien. This entire catastrophic multi-year disaster, which destroyed a family and cost hundreds of thousands of dollars, could have been prevented for the cost of a few hours of a real estate lawyer's time at the very beginning. Let's rewind the clock. The Andersons sit down with an attorney. What happens differently? First, the lawyer acts as a neutral, unemotional third party. They explain the risks to everyone involved, ensuring there are no misunderstandings. They recommend a formal appraisal. This documents the home's true market value, making the $200,000 discount a clear, quantifiable gift. Next, the lawyer drafts a proper purchase and sale agreement. This isn't a one-page form from the internet. It's a robust legal document that outlines every term of the deal. It explicitly states the sale price and acknowledges the portion of the value being gifted. This single document becomes an ironclad defense against any future claims of undue influence. It proves this was a thought-out, deliberate transaction, not some scheme to cheat a sibling. Then the lawyer addresses the tax implications. That $200,000 discount is a gift. For tax purposes, it's treated as if Mark and Carol wrote Emily a check for that amount. The lawyer would have advised them on the necessity of filing a federal gift tax return. By documenting it properly, they avoid any future audits or penalties from the IRS. Crucially, the lawyer would have insisted on a full title search and the use of a general warranty deed, not a quitclaim deed. This search would have uncovered that old contractor's lien, and the lawyer would have ensured it was paid and cleared before the property was transferred. The warranty deed would then legally guarantee to Emily that she was receiving the property free and clear of any hidden claims. She would have clean, marketable title from day one. And finally, to protect Emily from a potential future divorce, the lawyer might have suggested structuring the transaction with a note or a deed of trust, or drafting a separate document for Mark and Carol to sign, explicitly stating that the gifted equity was Emily's sole and separate property, not a gift to the marital unit. The lawyer's fee, maybe a couple $1,000s, would have served as the ultimate insurance policy. It would have protected Mark and Carol's intentions. It would have protected Emily from financial predators and legal claims. And most importantly, it would have protected the family itself. By making the transaction transparent, formal, and legally sound, it removes the ambiguity and suspicion that allows resentment to fester and grow into a full-blown family war. When you are dealing with family, a lawyer isn't a sign of mistrust. It's the ultimate sign of love and foresight. It's an acknowledgement that life is complicated, unforeseen events happen, and the best way to protect the people you love is to handle major financial transactions with clarity and legal precision. You are not just buying or selling a house. You are preserving a legacy, and in many cases, you are preserving the family itself. Don't ever let a desire to save a little money on fees cost you your relationships with the people who matter most. And that brings us to our fifth and final situation. This one is different. It's not about a weird title search, a zoning dispute, or even family drama. It's about the person sitting on the other side of the closing table. And it is, without a doubt, the most urgent, non-negotiable red flag that should have you picking up the phone to call an attorney immediately. The fifth situation where you absolutely need a real estate lawyer is when the other party has won. Think about this for a second. If you were accused of a crime, and the prosecutor was a seasoned professional lawyer, would you walk into that courtroom alone? Of course not. It would be insane. You would be hopelessly outmatched. So why, when you are dealing with the single largest financial transaction of your entire life, would you willingly walk into a negotiation where the other side has a legal professional in their corner, and you have no one in yours? Their lawyer is not there to be a neutral party. They are not there to make sure the deal is fair. They have one job and one job only: to protect and advance the interests of their client. Period. Every single word in that 100-page contract is an opportunity for them to gain an advantage for their client, and by extension, create a disadvantage for you. They are a professional, trained in the art of contractual warfare. Your real estate agent, as wonderful and as skilled as they may be, is not. They are not licensed to practice law. They cannot give legal advice. And they are not equipped to go head-to-head with an attorney over the nuances of liability clauses and indemnification provisions. Let me tell you a story about a guy named Michael. Michael was a first-time homebuyer, thrilled to finally be getting a piece of the American dream. He found a perfect house being sold by a couple who was retiring and moving to Florida. They were sweet, they baked him cookies during the showing, and they told him all about the wonderful memories in the home. They also mentioned very casually that their son-in-law, a lawyer, was just glancing over the paperwork for them to make sure everything was in order. Michael's agent gave him the standard state-approved purchase agreement. It seemed straightforward, but a few days later, an updated version came back from the sellers, full of red ink. The son-in-law had made a few minor clarifications, he said. He added a complex paragraph to the as-is clause, stating that the buyer acknowledges they've had a full opportunity to inspect and waive any and all future claims related to the property's condition, known or unknown. He slightly shortened the financing contingency period from the standard 30 days down to 21. He tweaked the language around the closing date, giving the sellers the unilateral right to extend closing by up to 2 weeks if their new home in Florida wasn't ready, without any penalty. Michael's agent told him it looked mostly standard. Michael, caught up in the excitement and trusting the sweet old couple, signed it. Then came the inspection. The inspector went into the attic and found a nightmare. Rafters were damaged from an old, poorly repaired roof leak. There was evidence of mold. The electrical panel was an outdated fire hazard. The estimated cost of repairs was over $30,000. No problem, Michael thought. This is exactly what the inspection contingency is for. He told his agent to inform the sellers he was backing out of the deal unless they paid for the repairs. The next day he got an email. Not from the sellers but from the son-in-law, the lawyer. The email was polite but firm. It pointed directly to the custom, as-is clause Michael had signed. It stated that he had agreed to waive all claims, known or unknown, and that the inspection period was for his information only, not as a basis for renegotiation or cancellation. The email concluded by reminding Michael that his $10,000 earnest money deposit was now at risk if he failed to close on the property as agreed. Michael was trapped. He was legally cornered. The sweet old couple suddenly weren't answering his calls. He was faced with an impossible choice: lose his entire life savings of $10,000, or buy a house that needed $30,000 of immediate critical repairs. All because the other side had a lawyer and he didn't. He brought a friendly handshake to a legal gunfight. Do not be Michael. The very second you learn the other party is being represented by an attorney, your next call is to your own. It's no longer just a transaction, it's a legal negotiation. Going in alone is not saving money, it's an act of financial self-sabotage. So let's recap the 5 horsemen of the real estate apocalypse, the 5 situations where you absolutely must have a lawyer in your corner. 1. You're buying from or selling an estate or trust. The complexities of probate, heirs, and trust documents make this a legal minefield. 2. The property has title issues. Liens, easements, boundary disputes. These are ghosts in the machine that can haunt you for decades if not properly exorcised by a legal expert. 3. You're dealing with zoning or land use complications. You're not just buying land. You're buying the right to use that land how you want. A lawyer ensures those rights are secure. 4. The transaction is with a family member. A lawyer acts as the crucial, impartial buffer that preserves both your financial interests and your most important relationships. And 5. The other side has a lawyer. Never, ever enter a legal negotiation unarmed. Hire your own champion to level the playing field. The common thread through all of these is risk. Hidden risk. The kind of risk that doesn't show up on a Zillow listing. The kind that can turn your dream home into a financial nightmare. People are often hesitant to hire a lawyer because they see it as an extra cost. I want you to completely reframe that thinking. A real estate lawyer is not an expense. It is the single best insurance policy you will ever buy. You pay thousands for homeowners insurance to protect against a potential fire or flood. Why would you refuse to pay a fraction of that to protect yourself against a guaranteed legal threat or a catastrophic contractual mistake? The fee you pay an attorney is finite. The cost of a mistake, losing your earnest money, buying a property with a $50,000 lien, or getting into a legal battle with your own sibling, can be limitless. So how do you find the right one? First, ask for referrals, but don't stop there. Ask your real estate agent, ask your mortgage lender, ask friends who have recently bought or sold. But then do your own homework. Go to your state's bar association website. Look for attorneys who specialize specifically in real estate law. You don't want a general practitioner who dabbles in real estate. You want a specialist who lives and breathes this stuff every single day. When you have a few names, set up a consultation. And when you sit down with them, I want you to ask them one critical question. Don't just ask about their fees. Ask them this: based on the details of my specific situation, what are the 3 biggest risks you see for me in this transaction? And what is your strategy to mitigate them? Their answer will tell you everything you need to know. A great lawyer won't just talk about filling out forms. They will immediately start thinking like a strategist. They'll identify the potential traps, the contractual loopholes, the points of leverage. They will show you that they are not just a service provider. They are your protector. Your home is more than just a building. It's the backdrop for your life's most precious moments. It's your sanctuary. It's your single greatest financial asset. Protecting it isn't being paranoid. It's being prudent. It's taking control. It's recognizing that in the high-stakes world of real estate, you don't get what you deserve. You get what you negotiate. And when the stakes are this high, you never ever walk into a negotiation unarmed.